Okay, it's 4:01. I'm going to go ahead and get started, and I expect people will continue to join us. But I'm going to go ahead and share my screen. Okay, good evening, everyone who's here. Thank you for taking the time to join us remotely for the education event for property owners and managers in Bellingham. This event is being recorded and will be available at a later date on our website on cob.org. First, I want to thank today's presenters. I'm going to be joined by Nicole Murray and David Hankin from the Northwest Justice Project. I'll be presenting Kate Bartholomew, a development specialist in the Department of Planning and Community Development at the City of Bellingham. We'll also have Mia Gover, who is the lead eviction resolution specialist at the Whatcom Dispute Resolution Center. And finally, Lorena Shaw, who's the assistant director, of community programs at the Opportunity Council. Just so you know, you're in the right place. I just wanted to go over what we'll be covering in today's training session. We'll talk about state landlord tenant law, federal fair housing law, relevant City of Bellingham ordinances and protections for tenants, and then finally, resources for landlords and tenants, specifically mediation resources, rental assistance programs, and briefly a damage mitigation program. Before we get started, I just want to let everybody know that we expect there will be lots of questions. Hopefully on the bottom of your screen, you will see a symbol for the Q&A. You should be able to click on the Q&A and type your questions into the Q&A box. Please go ahead and ask your questions in the Q&A box as you have them, but we will be holding all questions to the end. So as we go along, we'll be monitoring the questions and we'll be compiling them, and we'll read them out loud and address as many questions as we possibly can following all four of the presenters. Also, I just want to deliver a quick caveat to say that while we very much welcome your questions about the topics that are going to be covered here, if you have a very specific question about your circumstance or situation you're in, we cannot give legal advice during this presentation. So probably you'll be directed to consult with a legal representative or an attorney if you have specific questions. But with no further ado, I would like to hand it over to our first presenter, David Hankin from the Northwest Justice Project.
Thanks, Kate. Nicole and I really appreciate being invited to speak at this event. As we work for the Northwest Justice Project, we are legal aid attorneys, and so we come at our work from a perspective of tenants' rights and tenant defense. But I do hope we'll be able to provide you with some information and resources that you find useful. As Kate mentioned, we're giving legal advice. We're giving legal information, but not legal advice. I guess it's tough in 15 minutes to know what to touch on and what to skip. The only analogy I can give is maybe, like a doctor can tell you how to know if you might have appendicitis, but probably shouldn't and probably wouldn't try to give you enough information to remove your own appendix. This picture is of a Russian doctor named Leonid Roganov, who actually did remove his own appendix. As far as I know, he's the only person who succeeded in doing that. It was 1961 and he was stationed in Antarctica, and he was the only person with any medical training. And so he was training to be a surgeon at the time. And so he decided to remove his own appendix and he got away with it, which explains the smile on his face. Next slide, please. So just a word first about the governor's moratorium. Once in a while, I still get asked if the governor's eviction moratorium is still in effect, and it is not. It did expire a year ago on June 30, 2021. Some of the provisions that you remember might have been codified into statute, so there are some remnants of that moratorium in the current law, but the moratorium itself did end at the end of last June. Most statutes related to tenancies in Washington are found in the Revised Code of Washington. You'll commonly hear that called the RCW. The organization is important to understand, and it's really very simple. We're lucky to have a well-organized civil code in Washington State. There are titles within the code, and within each title there are chapters, and then within each chapter there are sections with a numbering system. So, and of course, it's all just a web search away. This is the official government site for the Washington State Legislature. The most important title for our purposes is Title 59, which is titled Landlord and Tenant. And 3 really important chapters within that title are marked here. 5918 is the Residential Landlord Tenant Act. That is the chapter that covers most residential tenancies in Washington State. 5920 is a special chapter for the situation where the property is in a mobile home park or in a mobile home cooperative, where the tenant is renting the lot, but they own the structure they live in. So if you're managing that kind of operation, Chapter 5920 is really important to you. But for most landlords and property owners renting property, 5918 is the key chapter. And then 5912 is also really important because it relates to the legal process for terminating a tenancy. It has a lot of the rules and special definitions related to terminating a tenancy. To legally evict a tenant, a landlord has to, among other things, they have to allege that the tenant is unlawfully detaining the property, unlawfully occupying the property. And so the legal process for removing a tenant is called unlawful detainer, and a lot of those rules are in 5912. Next slide, please. So here's the chapter view with each links to each of the individual sections. This is for 5912. It goes on and on down the page. The one thing I wanted to point out, if you're not familiar with this website, it's very useful to remember these links at the top for the complete chapter. You can click those buttons to display the whole chapter on one web page, or have it prepare the whole chapter as one PDF. And this is probably the best way to do word searches for a particular topic, or to find something back that you know you saw before and you just need to scan or word search to find something back. So don't forget about that complete chapter link at the top of the page. Next slide, please. So as I mentioned earlier, most tenancies are covered by 5918 RCW. Here's just kind of a list of some of the key sections. 5918.030 is the definitions section, and many chapters in the revised code have a definitions section early on. And if you're trying to educate yourself about the law, it's really useful to remember that. So, for example, a tenant in Washington State can be evicted for engaging in gang activity, but what's the definition of a gang? Well, there is an actual definition of what a gang is and what gang activity is. Those definitions are in 030, and those are particular to this chapter, so they only apply to this chapter. You might find a different definition of gang or gang activity elsewhere in the code, like in the criminal code or something like that. So the definitions can be very important, and they're often right there, isolated in a particular section. As you might expect, there's a section outlining the duties of the landlord, and another section outlining the duties of the tenant. These don't necessarily list all the duties, but that's the focus, and they make for important reading. Landlord's right of entry is kind of a frustrating section because it's a very long section, and it goes on and on about information about search warrants and those kinds of things. But the information people really care about, most people care about, is at the very end of that long section. So that's just a little hint about 150. The last 3 or 4 paragraphs outline the landlord and the tenant's rights and responsibilities regarding entry. And for anybody who's not already familiar with those, very briefly, landlords generally have to give 2 days written notice before entering a dwelling that they're renting out. That's 1 day if they're showing the unit to sell it or they're showing it to a prospective renter. And in case of emergency, the landlord can enter immediately. Tenants under the statute are not supposed to withhold reasonable access to the unit. And on the other hand, landlords should not unreasonably interfere with tenants' quiet enjoyment of the premises. In this chapter of the revised code, as in many parts of the law, you'll see the use of the word reasonable pretty frequently, and you won't find a definition of what reasonable means. Every attorney has their own approach to this, but I would say a good approach is to think of the term reasonable as indicating that the actual situation, how the law is going to be interpreted, probably depends on the specific facts of what is actually happening. And if a court had to make a decision, they would look at the facts, the specific facts to the situation to determine whether the parties were acting reasonable or not. Section 257, screening of prospective tenants. That's also a highly recommended reading. It is not a new section, but it probably has some surprises for landlords who haven't read it before. For example, a prospective landlord actually has a duty to make certain notices to a prospective tenant before they can collect any money from that tenant and before they can obtain any information about that tenant. They're required to disclose what type of information they're going to be accessing, what kind of information could lead to a denial, the names and addresses of the consumer reporting agency that they're using, if they are using a consumer reporting agency, and also whether the landlord accepts what's called a comprehensive reusable tenant screening report. The comprehensive reusable tenant screening report is an idea that sounds pretty good to me, but I'm not a landlord. The idea behind this is that the tenant would pay one fee to a company to provide a report to multiple landlords. It would be an online link that the tenant provides to the landlord. The company verifies the information. The tenant pays one fee for that information to be kept current for a period of time, and then the tenant doesn't have to pay a new fee to each prospective landlords. So landlords are not required to accept these, but they are required to let the tenants know whether they accept that kind of screening report or not. Also, maybe of interest in 257 is a description of what a landlord is supposed to do in the event of an adverse action. So if a prospective landlord rejects a prospective tenant, that's one example of an adverse action, and the landlord's actually required to give a written report on that. And there's no guessing on what that report needs to look like. The form of that report is right there in the statute. It's right there in 257. Now, the last 3 bullet points here are all sections that relate to eviction. So, of course, those sections are really keen interest to landlords and to tenants. And they're also where many, many changes have taken place just in the last couple of years. On this list, I put 1 asterisk for sections where there have been revisions in the last 2 years. 2 asterisks means it's an entirely new section. And of course, this is not a complete list of those changes. But I'll try to hit the high points of a couple of these changes. Next slide, please. So 5918-640 is commonly called the right to counsel. This is something very new to Washington State, but it's been the law in a few other places in the country. New York City was one of the pioneers. New York City, citywide, I guess, has roughly 10 times as many eviction actions as Washington State as an entire state. And they've made right to counsel work for a number of years now. There's cities in California that also has this. Washington State is the first state to implement right to counsel statewide and to fully fund it. The the law states that an indigent residential tenant who's being sued for unlawful detainer is entitled to an attorney provided by the state. So if a tenant's income is at or below 200% of the federal poverty level, or they're receiving certain public benefits, the court is going to consider them indigent. And this right exists regardless of why the landlord is choosing to evict the tenant. You'll hear later about it, other rights that exist, in particular for non-payment of rent cases, but the right to counsel exists for all unlawful detainer actions. So just to step this back a little bit to explain how the right's triggered. In general, any kind of lawsuit, one party will start the lawsuit against another party or parties with what's called a summons. It's a legal document. It announces the lawsuit, it demands a response. And it costs money to actually file the summons and start the case in court. Eviction actions in Washington State are heard in Superior Court, and I believe it costs $280 to file an unlawful detainer or an eviction action in the court. So some landlords will serve an unfiled summons on the tenant and decide whether to file the case later. That's perfectly legal, but the right to counsel is triggered when that summons is served on the tenant, regardless of whether the summons is filed with the court or unfiled. The superior courts in different counties have their own rules to some extent. Not every county handles cases exactly the same, and they publish their own local rules, and they also sometimes publish what is called standing orders that are that give more specific details. So, for example, in some counties, judges hear unlawful detainers and the judge makes a decision. In other counties, commissioners make the decision. In Whatcom County right now, these matters are heard by a commissioner.
Sorry to interrupt, David. Sorry, you have 2 minutes.
I have 2 minutes left. Somehow time has flown. All right, so let's skip ahead to 650. The basic message on 650 is that instead of a situation where month-to-month agreements could be terminated on 20 days notice without any reason being given, and after a lease expired, the lease could have been written so there was no further tenancy, it ended without further notice, that has changed. And if you're trying to find an attorney, you want to find an attorney who is familiar with this section. Attorneys who may have practiced unlawful detainer in the past, took a case every year or two or a few cases a year, they may not be up to speed on this. It's a complex section and it's really detailed, but the basic message is a landlord can no longer terminate a tenancy without some separate written notice. And often they need a particular reason, a particular just cause to terminate. Next slide, please. I also wanted to talk about 2 other resources. If you're not familiar with Washington Law Help, give it a try. This is produced by Northwest Justice Project. The documents and guides focus on tenants' rights, but it's useful information for landlords as well. You see the yellow arrow there where there's clickable links. And then another useful resource for actually finding an attorney is the Bar Association website. And I just wanted to point out that if you click on legal directory, almost invisible is an advanced search button. And of course, there's other ways to find an attorney, but if you do choose to use the Bar website, I highly recommend that advanced search feature. Next slide. You get to choose many different criteria. I would say you choose a practice area, landlord, tenant, eligible to practice, yes, to weed out the attorneys who have died or retired, and then down to the lower right, choose Whatcom County or whatever county you're searching for an attorney in. When you search with these few settings, you're going to get a list of attorneys who are working in this particular area of law. That's really all I have. I just wanted to say thank you to Kate again. and turn it over to Nicole.
Thank you, David. Good afternoon, everyone. My name is Nicole Murray, and I am also an attorney with Northwest Justice Project. And as David mentioned at the outset of his presentation, this is intended to be legal education, not legal advice. I will be covering fair housing law, which is an incredibly complex area of the law that you could spend weeks, if not months, reviewing and diving into, and I will be giving a 15-minute overview. So please just keep this in mind that this will be a broad overview here. So next slide, please. So fair housing law is a body of law that protects the right of all people to be free from discrimination in the rental, sale, financing, or advertising of housing. Next slide, please. Fair housing law stems from a number of different sources. So the primary sources I have listed here, there's a body of laws under federal law, most commonly the Fair Housing Act. And Washington also has its own counterpart, which is the Washington Law Against Discrimination. And there are also some provisions in the Residential Landlord Tenant Act at 5918, which David just discussed as well. There are some distinctions between what is covered under federal law and what is covered under state law. For today's presentation, I am combining those together because as a landlord in Washington, both the Washington law and the federal counterpart apply, so you want to be aware of both of those. Next slide, please. So fair housing law protects any action or prohibits any action or rule with a discriminatory effect. It's important to note that the intent to discriminate is not required. A practice can be prohibited where if it has a discriminatory effect, if it actually or predictably results in a disparate impact on a group of persons because of membership in a protected class. And I will cover those protected classes next. But it's important that it's the effect that is analyzed and reviewed. It is not the intent. So next slide, please. Fair housing law protects a broad group of people. So it protects against discrimination based on membership in any of the following classes here. So most commonly, we usually have race, color, sex, national origin. Washington law goes further and protects against discrimination based on being a victim of domestic violence, gender identity, or political ideology as well. So there's a very broad group of people that are protected by these series of laws. Next slide, please. And fair housing law applies to virtually everyone engaged in the rental or sale of housing and housing providers. So the entities here are virtually everyone involved in this process. And the types of housing, again, are virtually everything that is offered. There are limited exceptions for property owners who live in the dwelling that they are renting, and for some property owners who own less than 3 single-family homes. But if that's something you think may apply to you, it's definitely important to consult with legal counsel because it's a very fact-specific inquiry. So next slide, please. And again, the activities that are subject to fair housing law and are protected by fair housing law is virtually everything involved in the either sale or rental of housing. So it starts with the advertising and screening process. It extends to rules and regulations and goes all the way through to eviction. Next slide, please. So now that I've laid out essentially the broad overview of what fair housing is and what it applies to and protects, I'd like to cover a few specific situations that tend to come up most commonly within the umbrella of fair housing. So the first is families with children. Housing providers cannot discriminate against families because they have children. So it is required to rent to families with children unless the housing is age restricted. We see this most commonly in communities that are for age 55 or older, which is covered under housing for older persons. Housing providers must also set reasonable occupancy standards. They cannot charge a surcharge for children They cannot establish rules that target children. And they also have to integrate families throughout the complex. So families with children cannot be segregated into a certain area. And notably as well, child support, any child support received must be counted toward income for a tenant, which brings me to the next slide here. Next slide, please. So another very common area of federal fair housing is source of income discrimination. And I said federal fair housing, but this also is protected by the Washington Law Against Discrimination and the Residential Landlord Tenant Act as well. So housing providers may not discriminate against renters or potential renters based on their source of income. Next slide, please. So this includes activities such as refusing to rent to someone because of the source of their income. There is a very limited exception if the source of income would require the unit to pass inspection and it will cost more than $1,500 to fix up the unit to pass inspection. And the landlord either cannot or will not get money from the landlord mitigation program. This again is a limited exception. And we see source of income requiring the unit to pass inspection, most commonly with federal or state benefits. Additionally, a landlord cannot charge someone more rent than someone who does not get public benefits or tell the prospective renter that the unit is not available when it is. So essentially, tenants who receive different sources of income must be treated equally as those other tenants are. So next slide, please. And again, protected sources of income include federal, state, and local benefits. Most commonly, these are SSI or SSDI or TANF. Also, rent subsidies from federal, state, or local programs are protected as well. This is most commonly seen through the Section 8 voucher program. And additionally, short-term rental assistance is a protected source of income. Opportunity Council will be presenting later on, but they are the primary source of rental assistance in Whatcom County at the moment. So those grants of short-term rental assistance are also protected income. The next slide, please. I'm going to shift now to the reasonable accommodation process. So the fair housing laws require that persons with disabilities be accommodated. And I will cover that next, but a person is considered to have a disability if they have a physical or mental impairment that substantially limits one or more major life activities. They are also considered to be disabled if they either have a record of such impairment or are regarded as having such impairment. So next slide, please. A person with disabilities is entitled to ask their landlord for either a reasonable accommodation or a reasonable modification. A reasonable accommodation would be a change in a rule, policy, practice, or service that may be necessary to allow a person with a disability the equal opportunity to use and enjoy a dwelling. So this could be something like moving a tenant with mobility issues or a tenant who uses a wheelchair to a ground floor unit. It could also be giving a reserved parking spot to someone who has mobility issues or uses a wheelchair. Additionally, tenants can ask for what is called a reasonable modification. This is slightly different because a reasonable modification would actually be physical changes to a dwelling or common area that are necessary for a resident to use and enjoy these spaces. And the big distinction with a reasonable modification is that it is paid for by the tenant. The tenant bears the cost of those modifications, whereas a reasonable accommodation, that cost has to be borne by the property owner. Next slide, please. So it's important to note that a reasonable accommodation has to be both necessary and reasonable under the law. So a necessary accommodation is one that either frees the tenant from a rule, policy, or practice that interferes with their right to use and enjoy the dwelling, or it can enhance the tenant's quality of life by ameliorating the effects of the disability. That could be something like moving a tenant to a ground floor unit or assigning a reserved parking spot. And a necessary accommodation is also one that enables the tenant to satisfy the essential requirements of the tenancy, the same as a non-disabled person can. This could be something like if your SSDI monthly payment comes in on the 15th, changing rent to be due on the 16th rather than the 1st to accommodate that tenant. Next slide, please. So in addition to being necessary, the accommodation must also be reasonable. And this applies to both accommodations and modifications. So if an accommodation would cause an undue financial or administrative burden, that could make the accommodation unreasonable. The considerations that are come into play here are very fact specific. Again, courts would usually look to the cost, the benefit to the tenant, financial resources of the provider, and whatnot. And it is reasonable to expect some cost or financial burden on the housing provider. However, a fundamental nature a fundamental alteration of the program of what is offered also exceeds the scope of what is reasonable. And a direct threat, if the accommodation would create a direct threat, that does not have to be granted. So next slide, please. I've mentioned some of these already, but very common reasonable accommodations that we see would be something like waiving a no pet policy or pet fees to accommodate either a service animal or an emotional support animal. Some tenants may require receiving written documentation rather than verbal, or meeting with a property manager or someone who can explain the lease agreement and the rules. So next slide, please. And lastly, I wanted to cover the process for a reasonable accommodation or modification request. So whether something is necessary and reasonable is a case-by-case basis that is very fact-specific. Housing providers must consider each request separately without regard to prior or future requests. And what's very important to note here is that if the housing provider finds that a reasonable accommodation or modification is not reasonable, they must engage in an interactive process with the tenant or the requester to determine if something else is feasible. So if on first glance, the request made does not seem to be reasonable or necessary, the housing provider has an obligation to engage in a dialogue with the tenant to determine if there is another accommodation or modification that could be provided. And failure to do this, failure to agree to a feasible alternative, or failure to engage in this interactive process does constitute a denial of this request, which can create liability for disability discrimination. So with that, I will hand it off to the next presenter. Thank you.
Thank you so much, Nicole and David. So I'm going to jump back in here and talk about just a couple City of Bellingham ordinances very quickly. However, first, I just want to address, I'm seeing a lot of questions in the chat about whether this will be recorded. Yes, it will. Heather, our administrator, is going to put that link in the chat for you, in the Q&A for you. This is going to be recorded, and yes, there will be a Q&A session at the end, and we'll be answering as many questions as possible at that time. So just going on to some of the City of Bellingham specific ordinances that do not apply elsewhere. So these are only for landlords or property managers who are working or own property in the City of Bellingham limits. Ordinance 2018-02-004 took effect on March 12th, 2018, and it added 3 protections for renters in Bellingham. The first was that landlords and property managers cannot refuse to rent to a tenant based on source of income discrimination. Since this was passed, the state of Washington passed very similar protection banning source of income discrimination. So I won't go into that any further because we covered that already. It also requires a 60-day notice of rent increase for increases of 10% or more, and requires a 60-day notice to vacate for month-to-month tenants. I'll go into a little bit more detail on those two. So the 60-day notice on a rent increase, BMC 6.12. So just so you know, if those of you have not ever been to the City of Bellingham's website, it's cob.org. And you can just search BMC or Bellingham Municipal Code and put in 6.12, and you should be able to read this in full. But it was enacted to increase protection for renters to provide a 60-day notice of a substantial rent increase. And this is important, the substantial part. We're defined in the code as when landlords wish to raise a tenant's rent by 10% or more. And that 10% is based on 10% or more of what was paid over the last 12 months, must give 60-day written notice of this rent increase. So there's often confusion. There was a question about if there's any laws prohibiting rent increase. No, there are not any prohibitions on increasing rent in the state of Washington. However, this is just to say that tenants must be given a 60-day notice before that increase goes into effect. So any rent increase that does not comply with this ordinance would be unenforceable, meaning you couldn't hold them liable for not paying that increased rent, and that it's advisable that landlords should include this provision of notice of rent increase in each rental agreement and lease. So again, 10% or more. That's the magic number, and you just need to give 60-day notice of that increase. The 60-day notice of a termination, this is BMC 6.13, which was enacted to increase protections for month-to-month renters whose tenancies are terminated without cause. So I do need to spend a little bit of time here just to talk about what we mean by without cause. So this would apply only to tenants who you are giving them a notice that you would like to terminate their tenancy, meaning just no longer wish to rent to them due to no fault of their own. So if there's a tenant, let's say they signed a year lease, they've been living in your property maybe for a year and a half now, and their lease is over and they've been a great tenant, you have no problems with them, but you have a family member who wants to move to Bellingham and you would like to rent their unit to your family member. It's fine, but you would have to give them a 60-day notice that you would like to terminate their tenancy. It's not an eviction. It's just a notice that you would like to no longer rent to them because they are currently on a month-to-month. It's in the state of Washington. After your lease ends, it automatically transfers to a month-to-month tenancy. So you must give 60-day notice for that. And if that isn't followed in the case that there is an eviction, this is an affirmative defense, meaning that the tenant could assert that you did not give a 60-day notice or they did not receive that for a no-cause termination. And that's regardless of what it says in your rental agreement. So if your rental agreement, your original one-year lease said you would give a 20-day notice, but you only gave 20, but the municipal code would supersede that belief. So I get a lot of questions about whether this applies to regular leases. In the way I read it, it's specific to month-to-month tenancies. But as David mentioned, now there has been some provisions in state law which describe that you should give notice for any lease when you wish to terminate the lease. So hopefully that helps clear that up. So we're moving on now to some resources that are available in the community, and I'll turn it over to the Whatcom Dispute Resolution Center.
Hi, good afternoon, and thank you so much, Kate, for that introduction and the great information. I'm trying to start my camera and it's not working for some reason, but is this working for everybody? Can you all hear me okay?
We can hear you, so
okay.
Go ahead.
Sorry, it was working earlier. But I'll just go ahead and get started. My name is Mia Gover, and I am our lead eviction resolution specialist at the Whatcom Dispute Resolution Center. We've already heard so much useful information from the city and from Northwest Justice Project, and I'm pleased to be here this afternoon to share some information about the eviction resolution pilot program. I'll share just a little bit about our center and the work that we do. Then I'll focus my time on the eviction resolution pilot program, what it is, who can access it, and how to use it. So next slide, please. So the WDRC is a nonprofit agency, and we were founded in 1992. We're designated as Whatcom County's Dispute Resolution Center under RCW 7.75, and we are committed to meeting the evolving needs of our community, as is well demonstrated in the launch of the eviction resolution pilot program. Next slide, please. Our vision is for Whatcom County to be a community in which people approach conflict in creative and healthy ways. And our mission is to provide and promote constructive and collaborative approaches to conflict. We value impartiality, accessibility, empowerment, collaboration, communication, and integrity. Next slide, please. We offer a variety of services to our community, and we can summarize them in two main categories, those being conflict prevention and conflict intervention. On the prevention side, we provide adult and youth education and training programs to help our community build awareness and skills to productively engage with conflict. We believe conflict is a normal and healthy part of everyday life, and we also know that it can sometimes be helpful to bring in additional support to navigate a challenging situation. So on the intervention side, we provide mediation, facilitation, conflict coaching, restorative practices, and supervised visitation. Next slide, please. So more specifically to your interest, we have been providing mediation services to landlords and tenants for almost 30 years. Under RCW 7.75, dispute resolution centers provide conflict resolution services, including mediation, facilitation, and conflict resolution that can be an alternative to the court system and resolve disputes within the local community. Anybody in Whatcom County can contact our office to request community mediation services. And then here you can see some examples of goals and issues that commonly come up between landlords and tenants who are using our services. Next slide, please. So Washington State launched the Eviction Resolution Pilot Program, or ERPP, or you might hear us call it ERP sometimes, in 2021 to address and mitigate disputes about rent owed before an unlawful detainer can be filed in court due to unpaid rent. The ERPP was developed by the State Superior Court Judges Association in partnership with the State Office of Civil Legal Aid, dispute resolution centers, and other stakeholders at the direction of the Washington State Supreme Court. And it was codified by the Washington State Legislature and supported by the governor and the administrative office of the courts. ERPP was codified with the passage of Senate Bill 5160 in 2021, and it's influenced locally by Whatcom County Standing Order 21-2-001-37. And statewide, the statute can now be found under RCW 5918660. That's included in those chapters that David was speaking about earlier. Next slide, please. This is a 2-year pilot program that applies to any rent that became owing between March 1st of 2020 and June 30th of 2023. The program creates an avenue for tenants and landlords to access conflict resolution services, rental assistance, and legal aid to address and resolve non-payment of rent before an unlawful detainer action can be filed due to the unpaid rent. The ERPP helps tenants and landlords communicate through informal and formal processes from conciliation to mediation. These services promote dialogue and resolution in order to stabilize housing and prevent evictions. As impartial facilitators, we're able to bring parties together in dialogue to create solutions that work for them. The landlord and tenant may be able to access rental assistance to repay the rent owed. They might work out a plan for the tenant to pay the rent owed over time, or they could create a plan to move out without an unlawful detainer action, or any combination of those. Next slide, please. So who can access this program? ERPP is a statewide program, and it does have some county-specific requirements. Whatcom County tenants and landlords can access the Whatcom County ERPP run by our center. Tenants and landlords in any other county should contact the local DRC to that county to find out more of that information. You should know that the ERPP is offered at no charge to the tenant and the landlord. We provide confidential services in multiple languages and regardless of immigration status to all affected community members. Due to the design and the requirements of this program, ERPP must be initiated by the landlord when they want to pursue an unlawful detainer due to non-payment of rent. Tenants reach out to us often. Tenants cannot initiate ERPP, but they can access our community mediation services that I described earlier if they would like support negotiating unpaid rent or any other issues with their landlord. Next slide, please. So how does this program work? So through June 30th of 2023, landlords must give tenants the option to use ERPP before they can file an unlawful detainer in court due to non-payment of rent. The way that landlords start this process is by serving an ERPP notice and resource information form, along with a 14-day notice to pay rent or vacate. They serve this to the tenants with rent owed in Whatcom County, and at the same time send a completed copy of these notices to WDRC. And our email address is provided there. That's our preferred method of receiving these documents, and that initiates the ERPP process. You can find this form on the Washington State Office of the Attorney General website. It's available there in English, Spanish, and 16 other languages commonly spoken in Washington State. What happens once we receive your documents is that an impartial third-party eviction resolution specialist staff member will contact the tenants to invite their participation in the program. We'll connect tenants and landlords to any available rental assistance. We help landlords and tenants communicate and resolve disputes and provide referrals to other resources as needed. Next slide, please. So tenants may accept or they may decline ERPP services. Tenant participation is not required in Whatcom County. Once a tenant accepts services, WDRC will schedule a mediation session for the landlord and tenant to negotiate with the support of an impartial mediator. WDRC works with both tenant and landlord prior to the mediation to help them access rental assistance and legal aid, and to exchange proposals that may resolve the rent owed and address other issues that are important to the tenancy. Upon reaching an agreement, WDRC would issue a copy of that agreement to both the landlord and tenant and subsequently close their case. Important to know is that if a tenant declines services or if they do not respond to contact after 14 days, or if parties use this process and it does not result in a full resolution, the WDRC will issue a certificate of participation, which the landlord may then use to file an unlawful detainer action with the court. Next slide, please. For landlords, you should know that landlords must engage the ERPP process before an eviction for unpaid rent can be filed. ERPP begins when a landlord serves a tenant and sends to the WDRC an ERPP notice along with a 14-day notice to pay or vacate. We ask that you please send only one ERPP notice or documents for only one household per email. Batch notices, meaning emails containing multiple documents for multiple households, those will not be accepted. According to RCW 5918630, landlords are required to provide a reasonable rent repayment offer to their tenant at least through December 31st of 2021. A tenant may voluntarily engage in this process within 14 days. If a tenant responds to this notice and accepts services, the landlord is then obligated to participate in the process. In Whatcom County, a landlord who's filing an unlawful detainer case for non-payment of rent in court must include that WDRC certificate of participation, which demonstrates their participation in this program. And we do encourage all tenants and landlords to seek legal advice before, during, and after this program. Next slide, please. If you are a tenant watching this presentation, or if you are delivering information to a tenant, tenants should know that your landlord is required to invite you to use ERPP before they file an eviction for unpaid rent in court. So if you are a tenant and you receive an ERPP notice, we recommend that you contact WDRC right away. Oops, sorry. Our staff and impartial mediators will help you talk with the landlord about rent owed and help you access rental and legal assistance. If you're behind on rent, consider how you can help the landlord understand your financial situation in order to make a payment plan work for you. If you do not participate in ERPP, or if you and the landlord do not come to an agreement through ERPP, your landlord may file an unlawful detainer action. And again, we strongly encourage tenants and landlords to seek legal advice. Legal help may be provided to tenants free of charge. Next slide, please. So a really brief overview of the stats of this program is that we have received over 1,700 ERPP notices since our program started in October of 2021. We've had a 90% contact success rate so far, meaning that 90% of tenants engaged in our services. And when they did, we saw a 96% resolution rate. Next slide, please. I've got some quotes here to share from some of our clients. Some of our tenants recently shared, "I think what you guys are doing is quite amazing. Since the pandemic and everything got shut down, everybody got flipped upside down. It's amazing that there are people out there who are trying to help." Another tenant said, "This call really means a lot to me. It's been an emotional time with all of the uncertainty and financial stress. I had no idea what resources or services might be out there for me. Just to know that someone out there is reaching out to me and has some help to offer, it's very comforting. Thank you so much for calling me back." And on this slide, we've got some quotes from our landlord clients. A landlord shared, "I have been particularly burned by this eviction moratorium and had no hope of either evicting my defaulting tenant nor of ever recovering the accrued debt. But somehow, almost by magic, the WDRC and Opportunity Council streamlined the process, and both of them deserve the highest praise for their good efforts." And another landlord shared, "After the first few months of sending our tenants to ERPP, WDRC and Opportunity Council have helped knock down our delinquency list from 90K in arrears down to about 20K. So that's pretty fantastic." Next slide, please. And I just want to say that we welcome and encourage landlords and tenants to contact us and learn more about how ERPP can help you. It is our honor and privilege to partner statewide and locally to develop and provide a service that is meeting emergent needs. We're eager to help reduce stress and strain, divert potential cases from court, and support housing stabilization for landlords and tenants alike throughout Whatcom County. Next slide, please. We encourage you to visit our website to learn more. This program has a lot of moving pieces, and we've done our best to lay out a clear step-by-step guide for how to access the program and how it works. Our website is just whatcomdrc.org. The page specifically for this would be whatcomdrc.org/ERPP. And the best email address to reach our program would be erpp@whatcomdrc.org. You can also reach out to our case managers or our mediation program manager directly. Our contact information is right there. And we really encourage you to contact us to learn more about how our services can support your situation. Thank you so much. And I'll turn it over now to the next presenter.
Thank you all. Good afternoon. My name is Lorena Shaw. I'm the Assistant Director for Community Programs at Opportunity Council. Next slide, please. So I want to give a brief overview of the rental assistance program, and this is likely known to you as many different terms such as TRAP and ERAP and CARES. And so I just threw this slide on just to show you the number of different grants that we are talking about when we're talking about rental assistance. And at any given moment, we're using, specific fund to serve your tenants. So far, since April of 2021, we've distributed over $22 million of these funds out into Whatcom County to prevent evictions and to try to make landlords whole. Next slide. So the rental assistance, it's the federal and Washington state government's response to the COVID pandemic. And the program goals are quite simple. We are trying to prevent evictions, and we are also trying to promote equity in who is served by the program, with focusing specific attention on groups who have historically not been provided equitable access to rent assistance, and those who were have been disproportionately impacted from the COVID-19 pandemic. And currently, all of the funds that come through the federal and state government are due to sunset within Washington state on June 30th of 2023. Next slide. I want to talk briefly about the eligibility criteria. Currently, the households that are eligible must be behind on rent, and that is behind on rent one or more payments from March of 2020, and they also must still be occupying the resident that they're living in. Additionally, this is a program for lower income households, and the income guidelines are 80% of area median income. Within Whatcom County, for a one-person household, that's going to be about $50,000, just over $50,000. We are looking at, when we calculate income, we are looking at the last 60 days before the appointment date, or from calendar year 2020, and new as of just after I submitted my slides. We can also look at calendar year 2021 alone. So that is a new eligibility for us to look at. And I just want to note that United States citizenship is not an eligibility requirement of this program, and nor being any sort of legal immigrant. We do not look at immigration status at all for this program. Next slide, please. The allowable expenses are going to be, it's a combination of rent arrears. So remember that you must be behind. And so a tenant, we can pay for those rental arrears, and as well as the current rent that is owed for the month of the appointment, and then up to 3 months of future rent payments. It cannot exceed 150% of the fair market rent. And in Whatcom County, for a 2-bedroom, 150% of fair market rent is $1,881. The assistance can also be for utility assistance, and that can be for utilities that are included as part of rent, or those that for accounts that are held by the tenant, such as an electric bill with PSE, for instance. We can pay those utility arrears, as well as the current utility payments and future utility payments, up to 3 months. The last allowable expense category is what we call other housing costs, and that can include expenses that are such as rental fees and reasonable accrued late fees that are detailed in the lease agreement. Next slide. I just wanted to touch briefly on some of the community outreach and partnerships that we have in place for this program. We work with Northwest Youth Services, and they are a sub-grantee serving youth 18 to 24-year-olds, and they provide rental assistance directly through their agency under our, as a sub-grantee of our agency. Additionally, we partner with Community Development's Promotora program, the Hearing, Speech, and Deafness Center, and both of our tribal neighbors, the Lummi Nation and Nooksack Tribe. They provide outreach and facilitation and facilitate access to rental assistance services, and just basically they're out there helping people get connected to these programs. Additionally, I would be remiss if I did not speak about our wonderful partnership with Whatcom Dispute Resolution Center. We accept referrals directly from the staff at WDRC for rental assistance. For those in the ERPP process, they get priority scheduling and priority processing. As we know, those needs are very high in that program. Next slide, please. There are a couple of different ways to apply. So I want to talk first about how a tenant can apply directly. The first is through our online scheduling system. And if you aren't taking this whole link down, it will be included in the follow-up. But also if you go to our main website, opco.org, you can find it through there too. We have appointments are open on a rolling 60-day calendar. We're about 55 days out right now. So appointments haven't closed in a while. So people have been able to get in and get an appointment for this program. Need does remain high, but we are still able to get folks in. Additionally, just new this week, we have opened a live rental assistance scheduling and information line where, as long as there's appointments available in the schedule, people can call in to book those appointments as well. And that's open Monday through Thursday, 9 to noon and 1 to 4, and then Fridays from 9 to 12. Additionally, for those folks that are not able to participate in the online scheduling, and for the longest time it was just online scheduling, we also offer a accommodation request form for people that, one, may have disability that prevents them from participating, or that did not have a phone or internet access in order to make these appointments. And so that can be requested now through the rental assistance scheduling and information line, and also available online at the bottom of the page there. We have forms available. So anyway, we can get those forms out to people. They also have them at the front desk down at our main office at 1111 Cornwall, and that staff does assist with filling those out. So we don't want anybody left out of scheduling because of difficulties with online. We now have the phone number open, but this our appointment scheduling accommodation request form also remains a way to request an appointment. Next slide, please. And then the second way is going to be what we call landlord initiated. So a landlord may initiate an appointment, and essentially what that means is you will give us some information about your tenant, and then we will reach out to the tenant to make the appointment with them. Eligibility for the program is contingent on the client's eligibility. So unfortunately, you cannot apply on behalf of your tenant, but you can initiate the appointment. And so at that same link, we have, when you go to the page and choose Whatcom County, the form will pop up, and it first asks you if you're a tenant or landlord. And if you're a landlord, it's going to give you fields to complete. And then that form is sent to our scheduling specialist, who will then reach out to the tenant and attempt scheduling. We will let you know whether we've been successful or not. We'll go to the next page. And when you submit, you'll just get this confirmation that it was sent, and then what you can expect next. We do ask that you only submit one form for each property, only submit it one time. We are getting them, and then we will contact your tenant in the order that we've received your submission. And like I said, we are sometimes up to, that 60 days out, 8 weeks, just depending on scheduling availability. Your tenant will have 5 days to return our contact. And then if they're not able to make contact, we will let you know that we were unsuccessful. And if we were successful, we'll let you know that too, and let you know when that appointment time is. Next slide. Just kind of a brief overview of our application process. So we do a phone appointment with every applicant. They answer our eligibility questions. We get information from them about, what's owed, who their landlord is, their income. We go through that whole eligibility piece. Once we're complete with that, and typically that can be handled at the time of the appointment, sometimes there's follow-up, but sometimes not. We then are going to reach out to you, the landlord, and communicate to get confirmation of what is owed. There is a payment agreement form that we then send to you, and oftentimes this is primarily sent via DocuSign to try to make it easier for everyone. That form will state what you are agreeing to and what the dollar amount associated with the arrears in the future months are. Then that file is going to go through a certification. So we certify 100% of our files. This is really important to ensure that your tenants are eligible. We are looking for any fraud flags. And unfortunately, this program across the country has had some level of fraud in it. And so we have extra steps that we take to ensure that no fraud is being committed. And then once that file is certified, we are then going to issue payment. So that's just a brief overview of what that process looks like. Next slide, please. I wanted to bring up what the agreements are in that payment agreement form that I referenced. And there is 7 agreements essentially that a landlord is agreeing to. And that includes that you're going to accept the dollar amount that, that has been discussed about what is owed, and that there will be no new late fees, that the rent will not increase for the household for at least 6 months, and that 6 months starts from the date that you sign the document. And then there's some additional ones. I'm not going to go through the question that comes up most is, when can I raise rent again? And when does the 6 months start? And that really starts from that date of signature. A W-9 is required for individual landlords, we do checks on any property management firms that are new to us. We work with many, so we're familiar with so many of them, but we do require, we do checks for any new LLCs or property management firms or individual landlords that come through, just to ensure that they are the appropriate entity to receive the payment. Next slide, please. I wanted to touch briefly on the Commerce Landlord Damage Relief Program. This is not a program that is run by Opportunity Council. This is directly provided by the Department of Commerce, Washington State Department of Commerce. And its goals are to, it provides landlords with that incentive and added security to work with tenants who are receiving a rental assistance or a subsidy. And that it will offer up to $1,000 and up to 14 days rent loss to landlords in reimbursement for some potentially required move-in upgrades. And then additionally, it can offer up to $5,000 in qualifying damages caused by a tenant during tenancy if they are receiving a rental assistance or subsidy. And as Nicole said earlier, rental assistance is considered a type of subsidy and is covered by this program. There's a couple of links in there that once this presentation is shared, you'll be able to link to and get some more information about that program. Next slide. All right, well, I want to thank you all, and I look forward to any questions that you have, and I will turn it back over to Kate for the question and answer.
Thank you so much, Lorena, and to all of our other presenters. That was an excellent overview of a lot of information. I know there's questions, and we will get to that momentarily. I did just want to point out a new landlord resource website that is hosted by Western Washington University. We've heard from many property managers, owners, and landlords in the community that it's hard to find information. It's often depending on the question, on the source of information, it's on lots of different websites and lots of different places. So we're trying to create a central resource where landlords and property managers and housing professionals can go to find information about trainings, networking, and links that are helpful. If you visit the link here through the Office of Off-Campus Living, it's the network of Whatcom housing providers and the Office of Off-Campus Living. We're building out that website now, as in this week. So there will be more information to come, and there's also a listserv where you can sign up to get information about other events or training in the community. We're going to try to coordinate a little bit better between our various agencies, that being the Bellingham Housing Authority, the Opportunity Council, Northwest Youth Services, and the city, so that we can co-sponsor more trainings like this, so that people like yourselves who provide housing to tenants can go ahead and avail yourselves of those resources a little bit more easily. So there's the link for that, and we look forward to growing that new resource. We have lots of questions, so I'm going to go ahead and stop sharing my screen. I want to ask our panelists if they could turn on their camera, if they wouldn't mind. And I'm going to introduce a couple other guests we have here. We're also, in addition to the panelists, we're joined by Tyson Stapp from the Bellingham Housing Authority. He's there. Also Lisa Manos from the city of Bellingham, and who can answer more questions about fair housing, and also Heather Avon, who manages our rental inspection and safety program. So if there's questions about those programs, we do have folks available to answer them. I want to say our panelists and guests have done a phenomenal job in the Q&A of answering questions. You can see many great answers there. But for the benefit of those of us who might be watching this recording at a later date, and those who are watching on BTV, they won't be able to see those answers. So I'm going to read a few of them aloud. And if you have other questions that are still lingering, please go ahead and type them into the chat, or excuse me, the Q&A, and we'll answer as many as we can. So first of all, I just wanted to, there's a lot of questions about evictions and notice to vacate. And there was a general question that maybe we could start with David, if you want to answer what the difference is between an eviction and a notice to vacate.
Well, eviction is the overall process, it's a court process for terminating a tenancy and having the court order the sheriff to remove a tenant. So to walk it back, the only person who can require a tenant to vacate their dwelling is a sheriff's deputy. The sheriff's deputy is not going to do that unless they have been issued a writ. It's called a writ by the court. The court is not going to issue that writ without having examined the facts of a case that's brought by the landlord against the tenant, a lawsuit. So that is the eviction process. And most evictions, just about all, cannot take place until a written notice has been issued to the tenant, and the tenant has failed to vacate after receiving that notice. Some notices can be cured in other ways. For example, a notice for non-payment can be cured by paying, or a notice to comply with the lease can be cured by complying. But many notices also give the option of vacating, and sometimes that is what solves the problem. So the notice is the first step in a landlord's process to correct a problem they perceive with the tenancy, whereas eviction is a term that kind of covers the whole process of attempting to terminate that tenancy.
Thank you. And so a follow-up question on that we received a few is that Jen asks, so the lease ending is no longer a just cause for ending a lease? Can you speak a little bit more to the lease ending versus and how that interacts with the notice to vacate?
Yeah, it's a great question, because before these changes went into effect, you could write your lease in such a way that at the end of a year, without any further notice, the occupancy terminated, the tenancy terminated, the agreement was done, and the tenant was required to move out. What's really changed is that you can no longer write a lease in such a way that no notice is required. Now a notice is required. And if people want to educate themselves on this, that's section 650, 5918, 650. Subsection 1, or the first part, is the rules where you might be able to terminate a one-year lease with a notice. It doesn't necessarily give a reason. Subsection 2 is the just cause reasons. There's 16 situations in which a landlord might be able to terminate. And I'll just say it's complex. we could easily talk for an hour about just that section of the statute. And that's why we highly recommend, if you're in that situation, to find an attorney with that.
Thank you very much. So I do want to answer, well, one quick follow-up question to that, and maybe Nicole, you can speak to this. Is selling your property a just cause for giving notice? And then actually, I'm going to add my own question onto that I receive frequently, that maybe you could also answer. If there is a current lease and the landlord, the property owner decides to sell their property and the lease is not yet expired, is that also a just cause for terminating a lease? So it's kind of a two-part question there.
Sure. I would recommend going to RCW 5918-650, which will cover, there is a provision where a landlord can issue a 90-day notice of intent to sell property if they are intending to sell, and that is a just cause. However, it does need to be at the end of the lease period. So if the tenant is currently on a month-to-month lease, then a 90-day notice of intent to sell can expire at the end of a month. But if there is a longer lease term going on, that notice can only be issued at the end of that lease term. David, do you have anything to add to that?
I would just add that this is one example of the kind of enhancement to the law that came out of the governor's proclamation. So at one point, the governor's proclamation had no provision for people selling their property. That was added in a later version of the proclamation. So in a sense, it gives an additional right to the landlord, because under the common law, the rule is that the lease runs with the land. So if you have a tenant on your property and you want to sell that property, the buyer needs to be made aware that there's a tenant, and the buyer buys the property with the tenancy, all rights and obligations related to the property. So this is an enhancement, I'd say primarily to benefit landlords.
Thanks very much. I wanted to respond to a couple of questions that came up about service animals. This is another frequent question we receive. So service animals and emotional support animals are two types of disability accommodations. So I have a question, and maybe Lisa, if you'd like to answer, and I think Nicole might have a follow-up as well. So the question is, what are the requirements for an emotional support animal letter? Some look very official and almost prescription-like, and some literally just say so-and-so would benefit from having an emotional support animal. So is there an acceptable type of letter? And maybe you could also talk about the difference between an emotional support animal and a ADA.
Do you want me to go first?
Go ahead, Lisa, you can start.
Okay. An emotional support animal would be a reasonable accommodation, and you'd want to do that when you're moving in, or as soon as you determine that you need that animal before it comes to live with you. And it doesn't have to be a prescription, but you do have to have something written by a professional. We have a perfect example on the City of Bellingham's website, and I think I copied it in the answer to that. If you look under that link, you can see exactly how to set up a policy if you're a landlord, how to accept those requests. Also, if you're a tenant, what kind of form you need to submit. It's a really helpful document. And I think the difference between an emotional support animal and what was the other thing you said? I think it's
service, generally a service animal, which is just I was going to add is usually just a trained dog or
right, but is for in public places.
Right. So an emotional
requirement.
Right. Emotional support animal is just for your home. It should be allowed if it's an accommodation to your disability. Whereas you don't necessarily, if you're a restaurant or a business owner, you don't have to allow emotional support animals into your business, but those who are renting out residences would have to make that as a reasonable accommodation if it's go ahead.
Something important on that subject is they're not considered pets. So if you have a no pet facility, you still are required to accept the reasonable accommodation for a service animal, and you cannot charge an extra deposit for that or higher rent because they have an emotional support animal.
Thanks. Nicole, did you have anything to add?
No, I think that covers everything.
All right, thanks. I wanted to ask a question, and this is, again, I think related to fair housing. There was a question about if there is a formula for how many people can share a 2 or 3 bedroom apartment. Nicole, would you have any, I know this one is a little murky. Would you have any advice or information?
Yes. Unfortunately, there is not a set formula. HUD, which is the Department of Housing and Urban Development, does set forth some guidelines that can be considered, but landlords are required to look into other factors such as the size of the rooms available, the size of the unit. So it is a very fact-specific inquiry. And I believe David noted this as well, but it is not legal to require that children of different sexes occupy different bedrooms. So that is one thing to note, but there's not a specific formula for how many people can occupy a unit. It's a very fact-specific inquiry.
Yeah, thank you. There was a question about any recommendations for a good source of rental applications and leases that work for Bellingham rentals. I do not know of any. Does anyone on this call have any information about? I think the advice that I've heard in the past is that if you are a landlord, you should really consult with an attorney to develop an agreement. And obviously you can use that again and again, but that would be the prudent thing to do. David, did you have anything to add?
I'll just make one more comment, which is that landlords who have not approached an attorney might be surprised at how economical assistance from an attorney is. If your past experience is, for example, divorce or criminal defense attorneys, those are highly adversarial areas of law. They can be very expensive. Attorneys who consult with landowners often are quite economical, and even hiring an attorney to help you figure out how to terminate a tenancy or whether you need to terminate a tenancy, often that can be quite economical. Nicole and I both see the fees that attorneys are charging when they are in eviction matters, and it's not uncommon to see an attorney charging a fee of under $1,000 for the entire court process of evicting a tenant. So I would say it makes sense if you have legal questions to see what an attorney would charge to give you exactly the up-to-date information you need. And there's quite a number of local competent attorneys to do that kind of work.
Thank you.
And just to add one more thing to what David said, there are a number of attorneys as well who will do a consultation. They charge a lesser fee, and you can bring your issues to them and discuss it with them and see what they can offer. So that is always an option too. But I certainly echo what David said, that it is certainly more affordable in this area than it would be in other types of cases.
Okay. There's a lot of questions about emotional support animals, and I think we might not have time to get to all that, but it does speak to the need to maybe have a follow-up event where we can focus on that. But I did want to ask a question about damages, and maybe Lorena can answer. If the emotional support animal causes excessive damages that cannot be recovered from the general deposit, is that something that can be covered from some of the other mitigation funds?
Potentially they can, yeah. For Commerce's mitigation program, it's up to 5,000, so it may not make you completely whole, but if the tenant is no longer there and they were receiving some level of subsidy, then generally that would be one that you could submit to Commerce for reimbursement.
Thank you. Yeah, and I'm just in general, I think there were some links that were shared in the chat about example policies for an emotional support animal. And there's some really great, well thought out policies that you're welcome to use that address things like, if if the animal is disturbing other tenants or other situations, like that. So please do take a look at those. It's available on the city's website as well as in the link in the chat. Okay, lots of questions coming in. Oh, yeah, there's also suggestions about good resources. The Rental Housing Association of Washington, there's one example that was shared in the chat, or the Q&A. If you can't see the Q&A, but you are logged into this event, you should be able to see a Q&A icon at the bottom of the Zoom screen. It's like two little call out boxes and it says Q&A. And if you click on that, you should be able to see the questions and answers if you are joining us via Zoom tonight. Okay, I think we're getting pretty close to time. I do have another question about rental assistance. So it says I have to wait at least 3 months to 3 to 5 months for rental assistance. Will that wait time be reduced in the future? I'm not sure if this is coming from the perspective of a tenant or a landlord.
Probably a landlord,
Okay.
yeah. And what I answered is, so the length of time to payment varies on a lot of factors. As I mentioned, that file goes through full certification. There are sometimes corrections that need to be issued. We are often waiting on a tenant response to a question that has come up. There may be some other issues we need to look into in a file. And to be very honest with you all, sometimes we have staffing challenges. As you can imagine, building the infrastructure for a program that as big as it is, we are a team of 20 plus when there was no team previous to April, has had its own challenges. So there are at times where we have capacity challenges. But generally speaking, we want to be far away from the 3 to 5 months wait time whenever we can be. And our goal is from the time that a landlord signs the payment agreement form that we are about 8 weeks to payment. But like I said, there's times where files are going to go back for corrections and extra, just an extra level of check that we need to do. We always encourage landlords. We are happy to hear from you and hear, your inquiries as to where your payments are, and then we can give you a real specific idea of how long that payment's going to take. So my information was included or will be included in the presentation, and you're welcome to reach out to me or calling the number that was provided for questions as well. We answer many landlord inquiries on that line.
Okay, I think we have time for one last question, and it's a little specific, but I think it might, it's sort of in the fair housing domain, and I think it might potentially apply to other situations. So this is someone who writes, they want to rent their house to adults with developmental disabilities, and the benefit of this being that the individuals would be concentrated to make it easier for caregiver supports and other modifications. Would this be a type of discrimination since we'd be focusing on serving one type of protected class over others?
This is a complex question, but I will say my initial analysis is that it would not be discrimination because you are not actively excluding a protected class. You're trying to serve a protected class here. But I think that this is a great example of a situation where it would be great to consult with an attorney on this.
Thanks so much. So yeah, we will try our best. If we did not get to your question, to post any. I don't know if we'll be able to post all the Q&A publicly, but we'll try to provide resources and links on our website. And this training and the PowerPoint deck with the links in it will be posted on the city's website within a day or two. So you can see that at cob.org under services. If you look for landlord and tenant resources, that's probably the best way to go. You can either search that or go to cob.org, look under services, and then find services for housing and tenant landlord resources, and it will be available there. I do want to thank all of my guests for their time this evening. Really great information. And again, please take a look if you can, or if you're interested in future trainings. We're going to try to make them more available to the community on a regular basis through the Whatcom Landlords and Housing Professionals group. So thanks very much to everyone, and have a great evening.